one of the important things when a client retains this is it's very important that they understand all of the steps in a criminal proceeding. And in many of my videos, I've broken down these steps from start to finish, what happens step by step. And one of the important steps is what's called a judicial pre-trial. And I'm going to explain what exactly that means because it's one of the most important steps to take in a file. You don't need a judicial pre-trial in every file, but I would say in most files you do. What a judicial pretrial is, it's simply a meeting with a judge. Now, the defense counsel meets with the judge and the Crown attorney and the judge in their office or in chambers. And there's different types of judicial pretrials, and sometimes they're combined within the same judicial pretrial. But one type is where you're there to get a deal approved that you've worked out with the Crown, or get the judge's input about what they would give on a particular sentencing. So let's say you're pleading guilty to a domestic assault, and there's some injuries, and the Crown is seeking 90 days in jail, and you think the sentencing range is more like 30 days. So you could go in front of the judge in chambers. The judge could review the file completely. They'll have the synopsis, review all the facts with you, you would review your client's background, and the Crown would make their argument for 90 days, you would make your argument for 30, and the judge might say, well, listen, I'll keep an open mind at the guilty plea, I haven't decided, or, you know what, Mr. Kruse, I like your 30 days better, I think that's reasonable. Crown, you're being too harsh, this is a lower level assault, it does require jail. Or they pick the Crown's lane, or they go in between, or they encourage the parties to reach a joint submission in between somehow. So that's one of the purposes, to try and resolve cases with a fair sentence so that your client has certainty, they know what they're going to be facing, and you're not happy with the Crown's position. For example, you think the Crown's position too harsh. Or another purpose of judicial pretrial is if the Crown and you have agreed on a sentence, you can go meet with the judge in chambers to see if they agree. Normally, judges go along with joint submissions, and sometimes you don't even need that judicial pretrial because you know they're going to approve it. But there are very delicate cases where perhaps the Crown had a weak case and they decided to go way down in their position because of that. That needs to be explained to the judge ahead of time, in my mind, and we get approval, and the client's then very happy, we have certainty, and we're not going into the guilty plea with all this risk. So that's one purpose, to try and resolve cases and get the judge's viewpoint. The other very key purpose, again, which sometimes happens within the same meeting in case you're going to go to trial, is to manage trial time. We have a limited amount of judicial resources and courtrooms in Ontario, so we have to be very careful about not overbooking trial time and utilizing resources properly. So whether it's in the Ontario Court of Justice or Superior Court of Justice, Crown and Defense Counsel will go into chambers and completely review all aspects of the trial and figure out how many witnesses are being called, what the basic legal issues are, trying to figure out how much court time to take up, frankly, and we come up with a proper trial estimate. In the Superior Court, we have to fill out extensive forms on this, which are very involved, like 20-page forms, which the judge reviews. We don't have to do that at this stage in the Ontario Court of Justice, although we may be heading there at some point in the future. But it's a real important thing we need to get this right, and the judge with their experience, Defense Counsel, Crown, we put our heads together, figure out trial time. It's a bit of an art form, it's not a science, but we're pretty good at estimating trial time, whether it's a 1, 2, 3, 4 weekday trial or month-long trial. But the science is not perfect, but the judge has great input in their experience, and we try and narrow trial issues too. We might get some admissions there and figure out, and sometimes the judge encourages people to resolve the case. They might say to the Crown, look, your case is real weak. You've got it all wrong here. Or they might say to Defense Counsel, you're all wet. Your charter application is not very good. I don't think a judge is going to acquit here. Now, that judge at the judicial pretrial is never the trial judge, because that's an open, closed discussion. There has to be an unbiased mind from a new trial judge. But that judge at the pretrial can do the guilty plea. So they'll let you know, yeah, your 30 days is fine, or Crown, I'm going with the 90 days. So that's in a nutshell what the judicial pretrial is. It's in closed doors in chambers. The client is not present, but you're fully instructed by the client, and you pick a lane. You head to trial or try and resolve your case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.